Hello, fellow Toolboxers. Welcome to episode 336. I'm Immigration Lawyer John Ravi, and it's our last episode that was in the vault. The Honorable Gregg, he's going to be a judge one day, immigration judge. Call him Honorable from now on. I'm going to mention that next time I see him. The Honorable Gregg of the Immigration Review Podcast, a recap of March court cases. As you know, this year has been just nuts with the North court cases. So a real thing to listen to gain. And then I'm going to be recording a new one with him probably this coming Tuesday. So we'll get some more updates there. But obviously, everything mentioned there is not intended for individual legal guidance. Consult with an immigration lawyer for your case, but you all know this is for fellow immigration lawyers. Having said that, talking about fellow immigration lawyers, check out the wonderful CLE our brother Joseph Sang provided about abandonment. We did a almost 1 hour CLE where we just talked to each other and broke down what we do when our clients are outside or people come to us outside for maybe 2, 3 years, maybe 5 years, maybe 13 years outside the United States. There's problems of abandonment, green cards expired. How do you get them back in the country, get their life up and running, save their families? It's amazing what can be done. And a lot of people don't know. So don't sell it off. I mean, he's done so many cases, thousands. He said, I was amazed. And there's a whole side niche business you can do just of this, which he's developed. So definitely 100%. If you're an immigration lawyer and you don't listen to this, you're missing out. I mean, you're really like at malpractice. I'll put it there because this is so fantastic listening to this CLE. I'll put it those kind of extreme words because they're valid. All you got to do is join our circle.so group. Just get your email. If you're most of you already remember if you're listening to this, but send me your email. I add it to there. You have to be an immigration. You have to be a lawyer, not immigration lawyer, but send your bar information and email address that you want to use there, and we'll put you in. And there's not only that, there's like 20 hours of other kind of material. What is a 3-year, 10-year bar, and going over the USCIS memo? What is what's called 245I? People don't know about 245I. Old timers know about it. New people don't know about it. So how do you catch 245I? We have the best broken down, practical everything in there. And once you see how practical, it's free too. So you'll be like, dang, John really hooks it up. Let me get involved in his courses. So start from there. See what fantastic information that's out there. There's also a white labeled version of our I-693 memo that we give to clients when they're going to go to a doctor that fills them in on what to expect from the doctor, what to ask. Because a lot of these doctors mess up. Like 10% of the time, we just had one yesterday. The doctor didn't fill out the page. I was about syphilis. He just left it blank. And so we got to get a copy. We got to review that. You got to go back and say, no, we're not going to pay for this again. You got to do it. So it just all the information is there to get it up and running. Check it out. Finally, if you're interested in getting your name out there, getting attention, letting people know how great an immigration lawyer you are, and you know a topic really well, a niche topic, come. We're going to be publishing magazines soon in higher volume. And we just need 2 or 3 page articles that are not scientific. They don't need crazy citations, but just breaking down how well you know the practice about a certain area and share so other immigration lawyers get better at what they do here. It's all about, there's two prongs to this toolbox. There's education and media. So it's like, how do we get entertainment, education, edutainment, if you will, out for lawyers, come immigration lawyers, come fantastic immigration lawyers to help build the practice to be the number one type of lawyer you could be and promote all these people, because a lot of you are great at what you do, but you don't coming in front of a microphone like I am talking all the time. Well, if I got the skill and the ability to get the attention, you come and fill out the content and I'll get you the attention that you deserve. And I've had the top, I don't want to name names in public like this, but the number of 1, 2, and 3 lawyers, essentially that immigration lawyers have been on the podcast. And they've told me that they got business just because of the podcast. People contact say, I heard you on the podcast. It's like, you don't have to be, the big names are getting it. Then imagine what could happen to your business. And get your stuff up running. So all we do is content to help other immigration lawyers. Pretty simple. Having said that, just email me, info@immigrationlawyerstoolbox.com, and let's get the show started. Hey, Kevin, thanks for coming on the show again. We're kind of jumping into recording because we were talking before this, and let's get this on the show. So this jump in intro, and Kevin Gregg, obviously here, one of the best, if not the best, immigration podcast, Immigration Review. So there is a case, Patel, where the government, USCIS, and the court, immigration judge, I believe, mistakenly thought that a false claim to citizenship happened when truly there wasn't, because they didn't get a benefit under the act in that case. But Supreme Court said, this federal courts can't go and review that. Is that the correct interpretation of what happened?
I mean,
the dissent kind of puts it out that way.
It's just like, we ended up coming and representing Mr. Patel before the 11th Circuit on en banc rehearing and before the Supreme Court.
Okay,
so,
wow.
I mean, whenever we're talking jurisdiction stripping, it is much more complicated. And we don't need to get into the weeds. Mr. Patel did, where I think we even assumed he did check the U.S. citizenship box on a Georgia driver's license application. a driver's license is a benefit under federal or state law, so that could lead to a false claim to citizenship. One of the arguments was that under matter of Richmond, it wasn't material because you can get a Georgia driver's license even if you're not a U.S. citizen. And that was a bit complicated. Is it the same driver's license and all of that? But I mean, then the 11th Circuit comes in and says, we don't think matter of Richmond is right on materiality at all. We don't defer to matter of Richmond. Materiality isn't an element of a false claim to citizenship anyway, which is just a very fun little side holding in Patel that nobody ever talks about because the Supreme Court didn't grant cert on it. So in the 11th Circuit only, matter of Richmond's second materiality component is not an element for false claims to citizenship. And in the en banc decision by the 11th Circuit, in the very last page of a 50-page decision, they say, we don't disturb this. Then the Supreme Court didn't grant cert on that. So I guess that's the law, but not everywhere because the Supreme Court didn't grant cert. So with Patel, though, the big issue was, is he the way the Supreme Court said is he eligible for adjustment of status? He's not if if he's inadmissible for a false claim to citizenship.
Mm-hmm.
And the Supreme Court said, 11th Circuit's right, we can't even review whether he was inadmissible because it was all tethered to his adjustment of status application. And adjustment of status is one of the 5 forms of relief listed at INA Section 242A2B that jurisdiction is stripped from reviewing factual issues. Other reliefs are adjustment, non-LPR cancellation, regular LPR cancellation, 212H, and I want to say voluntary departure. So those are the 5 forms, I believe, and I'm not sure on VD, but I'm pretty sure, that are listed at 242B. So a pure factual finding tethered to those forms of relief can't be reviewed by the circuit. Now, we think that's wrong, as did Justice Gorsuch in the dissent, because it wasn't a factual issue. It was it wasn't even a relief issue. It was a pre-relief issue. Is he inadmissible in the first
The
place?
legal issue. It's illegal. It's not a factual discussion.
Well, it was a factual dispute because the IJ also found Mr. Patel not credible.
Do you think that was the biggest factor in that? I mean, it must. I get. You can't
If he
really
was
answer that.
found credible,
Yeah.
if he was found credible, then the IJ would have had to agree that he didn't mean to check the citizenship box.
Yeah.
And then, assuming the 11th Circuit doesn't blow up the first Richmond element, which it seemed primed to do in a footnote, to be honest with you, then it wouldn't be an intentional false claim. And then he probably wouldn't have been inadmissible. So if you assume him credible and you assume there's no factual dispute, Mr. Patel very well might win and Patel doesn't come out the way it does.
Mm-hmm.
And we disagreed. We lost Justice Ginsburg died on the bench. Justice Barrett came on and wrote the decision she did. And we got Justice Gorsuch. And we didn't represent Mr. Patel below or before the 11th until they went en banc sua sponte. Patel is very interesting procedurally, but that's not why we're here. If it's one of those 5 forms of relief and if it's a factual issue, it's a very broad bar. That's what Patel says. But if it's not one of those forms of relief, or now after Gorel-Asprilla, which predates Patel, and now after Wilkinson, which is the first case I was going to talk about today, if it's a mixed question of law or fact, even if it's tethered to those forms of relief, you can review it. Now, Justice Sotomayor and Wilkinson, in unnecessary dicta, in my opinion, makes very clear that credibility is not a mixed question of law and fact, even though it arguably should be, because there is a legal standard for credibility, right?
Mm-hmm.
But that's not a mixed question. So applying, they probably did that because of what I just said about Patel. So Patel is the same under Wilkinson, as it must be. It's Supreme Court precedent. But if, like in Wilkinson, you have a credible respondent with facts that are not in dispute, in this case, it was about exceptional and extremely unusual hardship to the son, and it was not in dispute that the son suffered from a serious medical condition. Like, that's all there. The judge just didn't think it was bad enough to equate to the legal definition of exceptional or extremely unusual hardship. And Wilkinson says, even though 242B precludes review of non-LPR cancellation, we can review this, where there are no facts in dispute. And it's just about whether these facts met a legal standard. That gets you around the 242B bar to circuit review. That's what Wilkinson says. And quite frankly, is what Guerrero-Asprilla said as well, but Guerrero-Asprilla didn't have anything to do with 242A2B.
What in fact? Which one's the one where someone got pulled over and they said they were a citizen? They said that's okay in the ninth. Is that one of those cases?
That happened like a year and a half ago. Um,
I was
I was
surprised about that
actually,
one.
I think so. I was actually, I think I was out. I think Eddie and Liz did that for the pod. I read it, but
Oh
I
no.
didn't do it. But I remember all of this only matters if it's one of the five grounds. So I want to say that that case might have been a straight removability case. I don't know. If it's a straight removability case, then it's irrelevant. 242B has nothing to do with it. Then it's straight review factual findings for substantial evidence review, as is always the case. It's and it's the same with asylum. Asylum is not listed at 242A2B. Factual findings are reviewable
But yeah,
for
the context of
substantial
what is
evidence.
usually going to come up in the adjustment of status context.
It does
Yeah.
happen, and it does happen in the adjustment of status context, absolutely. And the fact that they're not reviewable, the fact that 242A2D does not save them in the adjustment of status context, and that the court is saying there is no federal court review, is by implication essentially destroying APA challenges to adjustment of status denials
Yeah.
because there is no savings clause. 242D, if there's a 242B issue, I mean, it all goes, 242D is what brings it to the circuit court. There is no district court level savings clause. So if you can't review these issues, and it's more complicated and Patel isn't directly on point, but it seems likely that the implication of Patel is that there's no district court review of adjustment of status claims. There are a few decisions holding otherwise, and there are creative legal arguments, and some judges have agreed with them, but that's that's a whole nother podcast, and I've done some interviews about it. It's really complicated.
Yeah.
Um, I mean, if you're doing district court litigation in an APA claim, you must be an expert on the jurisdiction stripping provisions because that's what oil's going to hit you with literally 10 times out of 10 in their motion to dismiss. You have to be able to tango with 242A2B, 242A2D, and all the other stuff in each circuit about just what is reviewable and what's not. And of course, Justice Barrett's very strong dicta in Patel.
Mhm.
But anyway, so Wilkinson, big savings. I mean, what else is a mixed question of law and fact? Unfortunately, so we know extremely exceptional and unusual hardship is, and you can get circuit review. Unfortunately, Justice Sotomayor in dicta says fact finding on credibility, the seriousness of a medical condition, the level of financial support that a non-citizen provides, that's unreviewable, I guess. I mean, a medical, as I said on my podcast, like the seriousness of a medical condition, like that's also kind of like that's also a mixed question of law and fact, not an immigration law and fact, but like, if they have Parkinson's, how serious Parkinson's
Yeah.
is a medical stand, but whatever. They said what they said. Um, but it really does seem to open the door to a lot of arguments to get around Patel, to make something a mixed question of
Yeah.
law and fact, and get circuit review. I mean, look, when we're talking circuit review, you've already lost twice by definition. So like you don't want to be here. You don't want to be here. Well, sometimes you could lose once and get overturned by the BIA. So sometimes in the rare case, you've only lost once. But like, we're just talking about circuit review, which is kind of deferential anyway. The Justice Sotomayor said, at least if it's a heavy factual mixed question, which is kind of a weird part of Wilkinson to me that I don't fully understand because I would think legal questions are reviewed de novo, but we'll see what happens.
You mentioned the
But
BIA. We got a notice from the federal reporter, whatever it is. They're adding a couple of seats to the BIA in a couple of days as
I
well.
saw that a final rule. I wonder if it'll get challenged by a state or something. I don't know, or challenged by fair, but I mean, whatever. The Trump administration expanded the board, and they didn't even do notice and comment rulemaking, unless I'm completely wrong about
No,
what
they
I
just said
remember.
that's what we're doing. Like
They
that's why I
just
was
did
surprised to get this
it.
notice. I thought you had the right to do it anyways if they're
Yeah,
executive
they
branch.
just did it, and whatever. Good on. I mean, I want more. I wish everything was notice of comment. I just wish that everybody played by the same rules.
Yeah. Yeah, that's why I was kind of surprised. I'm like, you guys need to tell us. I thought it was just one of those things you do. It is, you could do it, you know? Because even in the
Whatever.
Supreme Court, they could pack it if they want. There's nothing that prevents them other than just history or something like that, right?
Well, I mean, there would be the
Not many.
most. They would have to pass a law, Congress. So
Wait, it's there's no cap on the Supreme Court, right? Like
no,
the
but
president.
Congress would have to pass a law saying how many justices there are on the Supreme
But
Court.
yeah, it's because there is no law. As long as they get past the Senate, they could keep packing the court. It's just a matter of if they get approved.
I don't know. Actually, you're right. I don't. So, do you need a law that says the Supreme Court will henceforth have 15 justices, or can the president just appoint a justice and get? I don't. I feel like there's a law saying the Supreme Court has nine. I could be wrong.
If they're going to put limitation on the Supreme Court because it's the constitutional branch, it probably has to be an amendment of the Constitution to make that.
Well, the Constitution. I don't know. The Constitution doesn't say nine, but I
The
feel
Constitution
like
has no limits. It's just open ended. You could just
but,
judges. It could be
but I
one.
feel like there's a law. I could be wrong. I could be wrong.
I kind of just have no idea. So I'm kind of not good for a lawyer to say so I have no idea. But imagine because it's a co-equal branch for them. Well, actually, Congress can make laws against the executive too and restrict them. And
Yeah,
I guess, yeah,
absolutely. Would it be challenged? I mean, maybe, but
yeah.
I'm not. But what do you need a law? I feel like you must need a law. You can't just have a president who has the Senate
I think they could. I
without
think
a
if you don't want to
filibuster
do
who
that,
just
you just
starts appointing justices. That's insane. There's no way.
I think it's just habit. Like we don't do that. It's just what's holding them back. I don't think
I
there's a way
don't
to stop it.
know.
Yeah.
I
But
don't
it's
think
better we
so.
research. At least I researched stuff before I started saying it. But that's what I'm feeling. But thank you for that. This whole situation with review of these cases is so complicating. And now it's just it's a mess. I appreciate that. What next case do we have?
It is. But before I do
Oh,
that,
sure.
because with the Supreme Court, there's like every circuit has its thing. Like Supreme Court dicta might be dicta, but like when the Supreme Court has dicta, we pay attention. So when I do these cases, I'm always looking for that. Another one, good dicta for your BIA appeal from the majority. Quote, an IJ applying the exceptional and extremely unusual hardship standard must create an extensive record of his decision making, including detailed fact finding and the application of BIA precedent, end quote. That would be the first legal quote in any of my BIA briefs for a
Let's pause
cancellation
that
case.
there. Is this for if they're going to deny it or even if they're going to prove it?
Well, I wouldn't be appealing to the BIA if they're going to approve it. Yes, ICE could use that too, no doubt.
Yeah.
But no, it's just general. But that would be my first, quote if you know what I mean? If
Yeah.
you get a low record, and that is the BIA sees that, yeah, it's dicta, but like the BIA sees that they can't avoid that.
Yeah.
They have to follow what the majority said in passing in Wilkinson. So that's an interesting thing. I like to highlight those things when I can.
Good stuff.
So
What do
I
we
do.
have next?
A Norby Garland, published by the Fourth Circuit on particularly serious crimes. And I like particularly serious crimes because I mean I don't recommend committing them, but I like the analysis and the matter of NAM analysis, matter of NAM, because it's kind of malleable. This case affirms what I've always understood to be the law, but like IJs and the BIA don't like it. Maybe some of them don't understand it, and they don't always apply it. And that is this. So a particularly serious crime for asylum is any aggravated felony. And for withholding, to bar withholding, it's any aggravated felony where they've spent at least 5 years in prison. That's a pretty high bar. I mean, most people don't spend 5 years in prison.
Yeah.
So matter of NAM says, yes, that's what the statute says, but anything can be a particularly serious crime. It's this totality of the circumstance, fact-based analysis. It was a particular serious. That's a dangerous place to be in. But matter of NAM makes quite clear, as does its subsequent precedent, that in order to get to the facts and be, seeing and withholding is mandatory, remember, there's no discretion. In order to get to the facts and determine if something's particularly serious, the first element the IJ and DHS must get over is that it must be the crime must be of the type and nature to be particularly serious. If it's not, you don't get to the facts. You don't do any more analysis on the particularly serious crime. So if an individual, for example, is convicted of simple assault and are you there?
Go ahead, I'm here.
Sorry. So if an individual is convicted of only simple assault and in actuality they murdered someone, to use an extreme example, that crime will never be a particularly serious crime because they were convicted only of simple assault. It's kind of like a mini categorical approach. That's what matter of NAM says. And in Honor v. Garland, the BIA or the IJ didn't do it and they got dinged. In this case, it was conspiracy to commit money laundering. And they kind of just jumped to the fact that it was a pretty rough conspiracy that swindled elderly people mostly out of like $4 million and sent it to Ghana, I want to say. So yeah, it was $6.2 million,
Oh
200
boy.
victims. It's bad. It's like a romantic it's bad. It's bad stuff. But the person's convicted only of conspiracy to commit money laundering. 1956H, which by the way is a per se aggravated felony, but it didn't get the 5 years. He only got like 3.5. Not a per se withholding particularly serious crime. The IJ and everyone, they wanted to look at the fact that there were 6.2 million at issue and say it's particularly serious. Maybe that's right, maybe that's wrong, but the amount of money at issue is not an element of a conspiracy to commit money
Yeah.
laundering. All that must be shown, as the Fourth Circuit says, is that it requires nothing more than an agreement to launder money. And that's not particularly serious. That's not within the type of crimes that are particularly serious. Money laundering, maybe. But there are so many different types of money laundering at sections 1956 and 1957. Conspiracy is so broad, just an agreement to launder money. That's it. So Mr. Honor dodged a huge bullet there. Doesn't mean he's going to win withholding, but it means that he's not barred from it, even though what he did is quite serious. And by the way, it's interesting facts. His claims of persecution and torture is a fear of retaliation by the Ghana-based land guards, a mercenary militia that orchestrated the romance fraud scheme, and then allegedly knew that he cooperated with prosecutors. So,
Yeah.
what he did leads into the persecutory or torture claim. That doesn't mean that it's not viable. I mean, that's kind of what cat protection and withholding is for. It recognizes that these people aren't going to come to the court clean.
Yeah.
So it's interesting. This happens a lot in drug cases too. I won an appeal many years ago where the IJ held that the individual who sold, I want to say he sold like $20 worth of cocaine to an undercover cop, was barred under under Attorney General Ashcroft's matter of YL, which takes this whole concept and says like drug trafficking crimes are per se particularly serious. What he essentially did, Ashcroft, is said drug trafficking is always going to be of the nature that is particularly serious. Fair enough, but drug trafficking has its own requirements as well. And this particular Florida statute had already been determined to not categorically be a drug trafficking crime, including delivery, which is what our guy was convicted of, and blah, 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 blah. And the point is like, even when the attorneys general and BIA try to make this fact specific, there is often a preliminary narrow analysis, which is the best friend of the immigration attorney advocating for their client. You want to narrow it. Like, no, you can't
Yeah.
get to all that. I mean, if they're bad facts, you
Yeah.
can't get to all that unless you get over this hurdle. Here's why you can't get over this hurdle. That's law.
Interesting.
Also, Ben Winograd and Capital Area Immigrants' Rights Coalition, which is quite the team.
Yeah.
And it might be one reason that there are so many good Fourth Circuit decisions of late, because both of them are operating in the area, and that's what happens, right?
Speaking of that kind of stuff, I just saw on LinkedIn that our good friend Brian Green just started working with the classical law firm. So we
Oh,
have
did
another
he?
power group of litigators going at it.
Good for Brian. And Homero Lopez, who I've promoted on the podcast, he just got appointed to be a Board of Immigration Appeals member.
Oh wow.
Is my understanding. There's been no EOIR announcement yet, but it's not secret.
Okay.
Um,
Yeah, I hear you. Yeah,
yeah,
you
it's
were.
it's uh, it's
Boy.
cool. It's cool stuff.
So, any other cases? Oh, we just got two good ones this week or
One
this
more. I
month.
picked the good ones. And by the way, March was a lot of work. The circuits blew up in March. And there was a whole week. It was like 8 bad cases all in a row. I was like, oh my
Yeah.
God, I can't do this. I'm gonna have PTSD. Singh v. Garland out of the Ninth Circuit on March 22nd. And I mean, I don't want to make light of it, but like I on the podcast in not even 4 years have done like 13 Singh decisions. Like there's just I mean, maybe there's a lot of people named Singh out of India, and I think maybe it's a common Sikh last
Yeah,
name, but
I think
I'm
so.
not an expert. And there's a lot of Sikh claims out of India late, and
Yeah.
so all these man party claims, like they're all over the place, and cynics will say that because they're being manufactured, and people who aren't cynical will say it's because the BJP in India is persecuting man party members. I mean,
Yeah.
it's two sides of the same coin, and this is one of the decisions out of the ninth saying, no, it's the latter. So if you have a man party Sikh BJP fear claim, this is the case to read and review and to copy, of course, assuming your facts are there. But based on my review of these cases over the last 4 years, it's pretty common. I mean, low-level man party member or affiliate, uh, beat up a couple of times by BJP members, fled, got death threats, threats to family members. All happens in Punjab. Not making light of this. It's just a pretty common fact pattern. And the BIA and the Ninth Circuit is saying that is enough. That is past persecution. And you've got it on account of a political opinion, of course, assuming credibility. And once you have past persecution, it then becomes the government's burden to show that relocation is reasonable or that facts have changed. I don't think facts have changed. I mean, the BJP, as I understand it, still runs India. And these cases, they don't often talk about it, but I'm not quite sure how relocation is possible because I understand the BJP is the government. So, like, there's a presumption that relocation is not reasonable. I don't know if I'm misunderstanding what's happening in India. I know it's a parliamentary system, but pretty sure BJP is the government. But that's not getting analyzed. And let's just assume that that's not there, but you should always argue that there's a presumption of no relocation. But without a presumption of no relocation to be DHS, you're going to go and say India is a big country
Yeah.
and Punjab is only one state. And that's what they always say. And here's this quote from the Ninth Circuit saying, quote, "It is not enough to show that Punjabi police, who often are the persecutors too, that Punjabi police or other actors are unlikely to follow the non-citizen outside of Punjab because he is a low-level man party member and not a high-profile militant," end quote. That's a big quote because that's going right to the core of one of the most common arguments, even assuming past persecution. So big case for persecution of man party members and affiliates in India, and big case chipping away at ICE's ability to then meet its burden to show that internal relocation is reasonable.
Interesting. Interesting. I mean, they had this Sikh guy who was assassinated allegedly in Canada, and Prime
Yeah,
Minister there just like immediately
nuts.
blamed India, which politically it's like needs more evidence or something. But it seems like they're doing this kind of stuff.
No, it's not. I mean, I'm not going to sit here and be an expert. I went to law school with somebody who was very involved in this, and so that's been this has been the case. If I please, I don't. Pretty sure that it goes back to the 80s, probably even and
This
earlier
probably since Sikh
when
before Sikh came, they were having these problems in Punjab.
right.
So yeah, it's a
But
hundred
like
years, hundreds. Yeah, yeah.
but Gandhi, the female, I think no relation. I
Yeah.
could be wrong. She does like she permits like an attack on the Red Mosque, the Red
The
Temple.
commandos going. I remember some. Yeah, it's very holy for them. It's
I'm
very
butchering
personal.
this.
Yeah,
And then
yeah,
she gets assassinated by, if I'm not mistaken, her Sikh guard. Again, if I'm mistaken, I apologize. And so like this has all been going on for a long time.
yeah.
And certainly since I was in law school, 11 years ago, this is nothing new, but it does seem like they're heating up. And, you know, Prime Minister of India does promote more nationalistic
Yeah.
Hindu rhetoric, so maybe it's not surprising. But again, this is not where I'm an expert.
Yeah, yeah, no, that's the stories I know and stuff. It's interesting, but it makes life extra comfortable for people in that part of the world. That's another level of complexity to live with.
Yeah.
Well, I appreciate you coming on again, Kevin. It's always great work that you're doing. And yeah, you gonna be in Ayla, Chicago Ayla this year?
I will not. To the, my wife is pregnant. That's also common knowledge, like Homero Lopez being on the board, and
Well, congratulations. Actually, I
well,
told me
thank
that
you.
and I completely forgot. That's why I asked when you come in. So
So I
I keep
pulled
such
out
good
of.
secrets that I forget myself.
Oh, it's good. It's good to err on the side of secrecy.
Yeah.
So I pulled out of ALA National, but I will be at the Federal Bar Association conference in Salt Lake City, a bit closer to home and earlier in May. So,
Yeah.
but I'm saddened that I won't be at ALA National because I enjoy it a lot, but for good reasons.
I hear you. Well, God bless. It's gonna be wonderful. I'm looking forward to that, getting the pictures and everything. Thanks, Ken, for coming on again. Immigration Review Podcast, where podcasts are found. Very popular podcast, breaks it all down, and it's like it's such a force for good. It's been help promote. You just come on this podcast, you spread the love and the information. It's a really powerful thing you do. So I really appreciate it.
Thanks, John. Likewise.
Thanks, man. All right, everyone, have a good one. We'll talk soon.